Depends, like in the Second Circuit, you have some good arguments under Second Circuit law. Even though there's no federal shield law, you can make common law and First Amendment arguments. Unfortunately, some circuits, that's not going to be very effective. And we do have a very strong New York State shield law. So it depends where the subpoena would be issued. If it
would depend on the court, basically.
Yes.
But in Jan's hypothetical, she has us in every imaginable court. She has us being hauled in front of federal grand juries. She has us in the domestic relations courts. Then a fight breaks out with the governor and his wife. So frankly, I'm asking this question because I really don't know the day-to-day experience. All I know is when our court got a shield law question, we answered it in accordance with New York statute and New York Constitution. I'm wondering from the press counsel side whether you think about these dual jurisdictions.
It depends where the subpoena is issued. If it's a state subpoena, then you're going to argue the New York State shield law, which in New York for a confidential source is quite good. It's absolute. You couldn't argue that if it's a federal in the Second Circuit.
Well, let's see. We have a federal judge right here, one of the best I know, one of the best anywhere. Can you acquaint us a little bit with? I know it sounds great to say, "Oh, we in New York, we protect recorders," but surely the government of the United States has very good reasons to give greater protection to other interests. So, can you elaborate on what the federal position is and what your position is as a judge, because you're going to be getting the motion for contempt when the reporter refuses to answer. It's going to come before you and say, Judge, we want this person locked up because they are not telling us that a plane is about to hit the World Trade Center and we want to know the truth. Okay.
So, by the way, I've enjoyed listening to this enormously. Thank you for the chance to be here. As a judge, and I think this is widely recognized, we're a lot about process. So in this hypothetical, the U.S. Attorney's Office is doing an investigation, and it's mainly about the financial aspects of the revealed information, not so much the child abuse aspects. And they have served a subpoena on the reporter or the newspaper, and there's a motion brought into court to quash that subpoena. Again, it's focused on the financial records. There is, in general, no First Amendment right protecting confidential information or the right of the press with respect to resisting any such subpoena. There are qualifications to that. The Supreme Court's outlined, but that's not at issue here. But there is in federal law, and strongly described in Second Circuit precedent, a qualified privilege. There are two privileges, one to protect confidential information, one to protect non-confidential information. And let me start first with the non-confidential information, because I think that's really interesting, because there you see the federal decision that we need to protect the press as investigators. You can't have litigants in civil cases or criminal cases just using the press to do their research for them. So even when it's non-confidential information, there is a privilege that applies and a set of tests that have to be confronted to get the press to disclose their non-confidential information. For instance, outtakes from an interview. Everyone knows the interview took place. It's not confidential that someone gave this interview either as reported in the paper or disclosed on camera, but there are outtakes. Not everything was reported. So it's non-confidential, at least arguably, and you still have to pass tests to get access to it. But let's turn to this hypothetical now. This is confidential information. I'm going to assume, and I thought that was interesting, there are different kinds of agreements that could have been made with the source. One is not to reveal the source's name in the press report itself. A stronger one would have been, I will never reveal your name to anyone. Let's assume it's the second commitment that was made. So I am not going to give up the origin of the information that was disclosed to me, who gave me that flash drive. The U.S. Attorney's Office now has issued a grand jury subpoena to the news outlet. They brought a motion to quash. So, first thing, I have both sides before me. I'm not deciding this without hearing argument from both sides. Second thing, I have standards. And there are different formulations here, but let me just give you one. A clear and specific showing by the government that the information is highly material and relevant. And the material we're talking about here is not the financial records. The material is the identity of the source who gave the information to the newspaper. So that's an interesting hurdle, I think. Secondly, that the information is necessary and critical to the maintenance of, here, the grand jury investigation. Again, I think a tough hurdle in this hypothetical to overcome. And thirdly, that the information that is the identity of who passed on the information to the news outlet is not obtainable from other available sources. So you have three tests that the government's going to have to come in, given there's a motion to quash by the newspaper, and it's going to have to make argument to me on these. And I think with this hypothetical, I'd be interested in hearing from the U.S. Attorney, but I think they're going to have a hard time in this hypothetical passing this test. I would just say one other thing before I pass the mic, and that is many times, these issues disappear. They are worked out. Subpoenas are withdrawn, conversations are had, things go away. Now, we have opinions written, so we know not every dispute is resolved that way. Law gets made. But I think in, maybe once every 2 years, this kind of issue pops up on my docket, and almost never does it result in litigation. You have conversations, you talk about the law, they go back, talk with each other, and things just magically disappear.